All right, so the court calls the only case on the morning calendar, which is 22 SV 335, Dials versus, I'm pulling up the calendar, slow today. It's always fun when y'all watch me watch my computer. It's like my favorite part of the day. And the best part is that the system is called Justice. And so I get to say things like, Justice is slow today. Still thinking about it. There it is. All right, Giles versus Trinsic Williams, Voyager, Geico, Crum and Forster. All right, so let's do a little bit of housekeeping first. Let's just go ahead and have y'all state your names so that we got all that cleared up.
Josh Samuels for the plaintiff.
Okay.
Leah Parker, specially appearing for Crum and Forster.
Mark Kerr for the defendant Williams.
All right, give me your name one more time.
Mark Kerr for the defendant Williams.
Okay, got it. All right, and do we have a quorum? Is there anybody else that was supposed to be here? Because obviously there's a lot of names thrown around in the case, and a lot of attorneys who are second chair, first chair. Do we have everybody we need to have this hearing? Okay. All right, so do y'all want this taken down?
I do.
Yes.
Okay, and y'all split the cost and
That's fine.
talk to Kathy before you leave and sort all that out. Okay, so I have two items on my list, and I just want to make certain that what I'm looking for and what y'all are looking for from me are the same thing. So let's just talk a little bit of housekeeping. So I have today that we're dealing with a motion for default, and then moving over to a motion for summary judgment, potentially. We'll take the motion for default first, because that's the one that circles in on y'all. What do y'all have?
Is there another motion for summary judgment, or is that the one against us?
That's the coverage motion for summary
So the
judgment.
motion for summary judgment was deemed not ripe until after the default was ruled on, and we were told we would have 30 days to respond on the motion for summary judgment after the ruling on the default.
Okay, that's fine. I simply forgot that part of it. But I knew I had it in order that we had to do one first, and then we'd circle back to the second one. I forgot about the fact that I was going to give you.
Yes, that has not been briefed.
Yeah,
That
so-
will have to, if that has to be briefed, it will be briefed by a coverage lawyer. I'm not qualified to
don't-
brief that on for this client.
Don't panic on that. I just knew the order of events, and I had forgotten that I'd said that y'all would have time between the two. So that's going to be easy. So, all right, so mark that off as far as we're dealing just today with the default then. And any other housekeeping, anything else that y'all need to address while we're all here?
There will be one more thing. You had asked us to complete discovery. You want to start moving this to trial. We have been trying to get the defendant's deposition since our hearing in September. The defense was not able to find him, and then we issued a notice in January without agreeing on a date, giving them until April 9th to find him and set the depot, and on April 8th, we were informed that he still can't be found, so.
This is Trinsic Williams?
Correct.
And that's spelled, I think I'm saying it wrong, Tresnick, Treznic. Is that your client's?
Yes.
Okay.
Your Honor.
All right, well, we can circle back to that when we're wrapping things up today, just figure out if you need anything from me.
Yes,
So, all right, so let me mark that down. Okay, anything else from Crum and Forster Defense as far as housekeeping or anything you're looking for from me today that I might not have mentioned?
Your Honor, I mean, we contend we're not a party. We have not been involved in discovery, so I honestly, outside of my motions, I know very little about the goings-on in this case.
That's what I expected you to say, but frankly, a lot of times lawyers say things that I don't expect them to say, and that's how we get it sorted out. So we're on the same page. So, all right, anything else housekeeping wise?
No, Your Honor.
Okay. All right, well then that gives us 2 items on the list for today, and then circle back to the third if needed. So, okay, well then, y'all are welcome to, so obviously you can see y'all have microphones at your tables. You're welcome to use the microphones. You're welcome to move the podium. There's no jury present. We are live streaming out, so if your offices want to watch, it's on YouTube. But I just want to make sure y'all feel free to sit or stand or move as you prefer. You don't have to ask me. I just want to focus on this. This is a situation. I'm going to go ahead and tell y'all ahead that I'm having a very difficult time wrapping my brain around this one. I tried on 3 different occasions to really sit down and line it up. I haven't got this fancy new little thing that lets me create. It's the equivalent of the string and pins that you see in the movies that I'm trying to line it all up.
Is it the
And
Remarkable? Is that what you just showed us?
Yes.
I have one too, but
it's
I'm bad about
wonderful.
using it.
So, but I'm just letting you know that even with the fancy technology and the time, I've not been quite able to line this up. So don't assume I know anything. So with that said, I think you're up first. All right.
Thank you, Your Honor. So the default part of this is kind of a red herring here. It's not as important because the real question we want you to answer today is, do you have jurisdiction to reach that second question on coverage? Crum and Forster is a carrier. My client was a DoorDash driver on the day of an accident. He had pretty serious injuries. The liability policy for Mr. Kerr's client has already tendered. It was a minimum 25 limits policy. And so what we're trying to figure out here is, are these food delivery companies required to have coverage when they claim that they're not? So they don't need to have it. And if we reach that question and you decide it in my client's favor, he can tap into $1 million of coverage. And if not, and the case is pretty much over at that point. So what we're trying to figure out, and this is very difficult because it doesn't seem like there's a case on point on this particular issue, or even issues that don't involve carriers and people have made appearances. All the appearance case law I was able to find centers around whether people have waived service defenses or things like that, and figuring out the timing in which they appeared, not whether certain discrete acts constituted an appearance. This issue is not about some of the crazy plaintiff things I know you probably have seen with carriers, where the people want to add them to the caption or keep them in front of the jury. That's not the goal here. The goal is just to say they're a carrier. Statute allows state and superior courts to decide coverage questions when they appear in their own name. And that's what we're contending happened here, that they made an appearance in their own name. And once they put their toe on the ground, even if they want to change it later, you have jurisdiction to decide that second question. And so what happened here that we're claiming that they put their toe on the ground is, initially we had discussed whether there was coverage here. Crum contended there wasn't. This is all through informal discussions leading up to this. They asked for an extension of time while we were talking about trying to figure out what was going on here, because it was unclear what we were doing in terms of asking for coverage. And we entered into a stipulation that was filed with the court, giving them that extension of time. And we're contending that the filing of that stipulation was an act in furtherance of the litigation. Crum derived a benefit from it. They got extra time to answer. They didn't need to get this stipulation if they really didn't want to participate, because the statute gives them a lot of latitude on how to participate in a case. They can answer in the name of the defendant, they can not answer at all or do anything, or they can answer in their own name. And so if they really didn't want to participate, they never needed to approach us for that stipulation in the first place. They could have just done nothing and there wouldn't have been a default. And so one of the things I think you'll see in some of the old case law that's cited in our briefs is the courts definitely look into intent of the parties when looking into the actions of what they're doing. And I think it's the Jones case. It's one of the 2 cases I cited in my reply brief. It's like the best example of that. It's a partnership where the wife of the partnership was sued. The husband was never served. He attends trial with his wife, and the court says he didn't waive the service defense by being physically present in the courtroom, which is strange. But then the court goes on to say, we don't know if he's just there supporting his wife instead of consenting to the jurisdiction of the court. And so what all the cases center around is whether the party seeking to avoid jurisdiction has done something to show that they're subjecting them to the power of the court. And there's one case, I think it's the Terrace case. It's a 1930s case. It's one of the first citations I have in my initial brief. At the bottom of that case on Lexis, you'll see a paragraph that talks about it's anything other than contesting the jurisdiction of the court. And that can give rise to being subject to the jurisdiction. And so there are other case examples too that we've cited that show motions for continuance can get you that toe on the ground, motions for summary judgment. You have that Kelly v. Harris case where they didn't answer at all and then tried to participate later, and then that related back to when they were supposed to answer. So there's lots of different things that you can do that get your toe on the ground. The two arguments my friends on the other side are making here to say that doesn't apply, the first one I think was, well, we didn't file any pleadings in the case. And filing a pleading certainly can be evidence of subjecting yourself to jurisdiction, but that's not the only way that you can do that. So I don't think that really applies. The second argument they make is, well, look at the language of the stipulation. You can glean our intent from it. We put may instead of shall. So we left open, we reserved all our rights in the case. And I don't think there's a dispute that they've reserved defenses and rights in the case. I'm not here claiming they can't then change their election before trial, or that they can't raise the 9/11-8, 9/11-12 defenses if they want to, or if they applied. But the rights they're preserving are consistent with their jurisdiction, with the jurisdiction of the court. When you participate as a litigant, as a UM carrier, you are treated like everyone else. The only extra benefit that you get is that first option to choose between the three paths you want to take. And so I think the strongest evidence of intent here on the part of Crum is, if you didn't need this stipulation in the first place, why did you ask for it? You asking for it means you're intending to participate at least somewhat. And once that toe is on the ground, you can decide the summary judgment question. The lurking behind all this, in the why of all this, why we're all fighting so hard, because there's lots of different ways to decide coverage issues in a case like this, before, middle, or after, is a lot of these food delivery companies have taken the position Crum has taken here leading up to this point. And if we're correct about the merits of the summary judgment motion, there are thousands upon thousands of policies here that are violating Georgia law and not providing coverage to drivers when they should be. Their own drivers, right? Because they're delivering food. There are no passengers here. And the legislature recently changed that law to allow UM carriers to do what they're trying to say they could do now, select or reject coverage. So the reason why we're fighting so hard now to have you or not have you decide this question is because the group of policies that are subject to this issue, it's going to sunset in 2 years. It was passed in July of 2023. By July of 2025, there will be no issues as to whether there is coverage or not coverage for classes of car accident cases, unless the cases were already pending before the sunset. And so Crum does not want you to decide this motion now, because if they can delay, and wait till after trial when a DEC action has to be filed, they can make sure that there's no beacon out to others plaintiffs' lawyers about this issue here, because a lot of people don't know that, at least in our view, that there really should be coverage for not just Uber and Lyft, but all of these food delivery companies, Postmates, DoorDash, etc. So that is why we are so adamant about getting to this now. Crum is not going to resolve this case with us until they think they have exposure. And if we don't get this question resolved now, my client has to decide whether he's going to try the case with no guarantee of ever recovering anything. And so would it be the end of the world if he has to do a DEC action later? No, but that is our belief as to why there's so much fighting here about whether you can decide this question or not.
Okay. All right, that helped tremendously. Thank you. Anything? What else do you want me to tell? What else do you want to tell me?
Nothing unless you have any questions.
No, not yet, but I'll probably think of something.
Okay. Thank you.
Like I said, you may sit, stand, move, wherever you prefer.
I think I'll sit just because I have notes. Your Honor, I would first like to mention that the plaintiff's counsel indicated that the default is kind of a red herring. I would disagree with that because the plaintiff's motion for summary judgment, which would come up right after this, from my reading, seeks to prevent Crum Enforcer from being able to raise coverage defenses in this matter based on the default. So they're trying to use the default to get around a legitimate coverage decision on the merits here. And for that reason, the default is very important, at least for Crum Enforcer's purposes. I would agree, however, that the jurisdiction question is important. And I think the law is pretty clear on that the general, that the stipulation that was filed does not provide jurisdiction of the court over Crum and Forster in this case. It's general law across the United States. The general rule is that a stipulation to extend time to answer does not confer jurisdiction. In this case, specifically, we reserved all of our rights and defenses in our stipulation, which includes, probably most importantly, in a stipulation where rights are reserved, the right to challenge jurisdiction, and the right to raise questions about the validity of service. So here we have not answered, obviously. If we did answer, it is possible that we could raise jurisdictional or service questions that would place the jurisdiction of this court in question. Because of that, our stipulation cannot be a general appearance under the law, like the plaintiff is arguing. Plaintiff references Tate v. Laras, where he quoted them, or used a phrase from the case about how an appearance for any other purpose than to question the jurisdiction of the court is general. They do mention that. There's a lot of other discussion in that case, and the biggest point related to jurisdiction is that the law in Georgia is well settled that a general appearance gives court jurisdiction over that party. If something is filed and does not provide the court with jurisdiction, it is not a general appearance. The court then goes on in direct quote to say, a general appearance waives not only all defects in process, but even absence of process itself. Obviously, here, by reserving our rights in the stipulation, we did not waive any jurisdictional defenses or the right to proper service by the stipulation. And for that reason, it can't be a general appearance under Georgia law. I also disagree with plaintiff's counsel on the law that a general appearance in and of itself is sufficient to require a carrier to answer in one of these cases, or provide it with a deadline to answer. Sorry.
Okay, and as y'all are I know the cases, just to put it on the record, I know y'all are citing your cases as you go, and of course, I'm familiar with having seen them on your briefs, but what I'm doing is, as you are citing them to me, I'm actually going back through Westlaw to save them, since they're ones you specifically referenced in today's argument. So I may, from time to time, hold up and say, just let me catch up. But I just want you to know that as you're citing the cases, I'm pulling them up and tagging them as referenced.
Would it be helpful to Your Honor at least where we have the site available if we provide you with the full site?
Yes, that would be wonderful.
Okay.
That would also make Kathy's job easier eventually when I was gently leading us towards that, which is that, eventually Kathy will need to do a transcript maybe, and the full sites do make her job a lot easier.
Well, for the Tate v. Laras, it's Tate v. Leres. It's 59 Georgia App 6 from 1938. And the quote that I referenced is on, I don't know, it looks like possibly page 6 of the opinion. It's long, but it doesn't seem to have any other consistent page numbers that match, unless they're not in bold on this opinion. I apologize.
Interestingly, I agree with you. It has the southeastern page numbers, but I'm not seeing the.
So it's at page number 328 for the southeastern page numbers, if that's helpful. And the other part that I referenced, the quote is actually, appearance in pleading shall be a waiver of all irregularities of the process or of the absence of process and the service thereof. and that would be on the Southeast page number 327. So again, my contention is that a general appearance is not sufficient to require an answer of a carrier. In the Bohannon case, they specifically refer to the need to file pleadings for a carrier to be involved. They also indicate that the UMC has to choose to participate directly. So in this case, by filing a stipulation and reserving all rights, Crum and Forster had the right to make a choice still at that point. They had the choice at the time of filing the stipulation to answer in their own name, to answer in the name of the defendant, or not to answer at all. And they reserved all rights in their stipulation, which means that they did not make that intentional choice, which Bohannon references. What they did was reserve their right to make that choice until the date on the stipulation. Plaintiff indicates that the reason he believes filing pleadings is not the only way to become a party here is because the statute and many of the cases represent the phrase filing pleadings or taking other action. However, in all of the case law I've reviewed in this, I've never found a case that specifically defines what the court means by or other action related to an involvement of a carrier. There are certainly cases where carriers take other action in the case, for instance, filing a motion to dismiss at the beginning. Now, motion, as discussed in plaintiff's pleadings, is not, or in plaintiff's brief, is not a pleading, and therefore a carrier would have the right to file a motion to dismiss up front. And I think if this or other action was not included in the statute, a carrier wouldn't have the right to do that. They would literally only have the right to file a pleading and nothing else. And so that provides them with the opportunity to file motions as needed in these cases, or when they're involved, to be involved in discovery, because the right to file pleadings and other action isn't just to become involved initially, it's throughout the case. They're invited to be able to have other action. So I have not seen in Georgia case law where or other action requires suddenly the answer. I think from my reading, that is simply something that a carrier is permitted to do throughout their involvement if they choose to be involved. However, going back to plaintiff's point, if a general appearance was made and could have somehow conferred jurisdiction here, which as I've discussed, we disagree with, this filing could not have been a general appearance on behalf of Crum and Forster. And the reason for that is because Georgia law specifically defines an appearance of counsel for an incorporation, and here Crum and Forster is an incorporation, as entry of an appearance form, which is the specific entry of appearance form, or filing of a signed pleading. And here, neither of those were filed. Crum and Forster can't appear on its own behalf because it's an incorporation. It has to appear through representation of counsel, and my signature on the certificate of service line only in the stipulation is not legally sufficient under Georgia law to constitute a general appearance. So for that reason also, the stipulation cannot have presented an appearance in this case by which Crum and Forster should have been required to answer. I'd also like to point out, in my experience as an attorney, typically when a conclusion reaches results that are illogical or nonsensical, that tends to be the wrong conclusion. And here, one of the key points is that when a carrier has appeared, the law specifically states in these cases that at that point, once they have appeared in name and show their intent to be involved, they are required to answer within 30 days. There is no ability, there's no option for them to file a stipulation to extend time to answer. That's not a right that's specifically provided to them. Everything just says they have 30 days to answer at that point. And so technically, if this stipulation that we filed is an appearance that would require Crum and Forster to answer, it would have required Crum and Forster to answer on the date that the answer was originally due, and it would have effectively been a moot filing in and of itself. The other problem here is that the whole point.
I'm gonna do that part one more time
Yes.
more slowly. I did
Okay.
not track that.
Sure. So all of the law related to a UM carrier having to answer if something is filed where they show their intent to be involved, specifically says that once that's done, the UM carrier has to answer within 30 days of service. Specifically, there's no other leeway there, and so there's no, like, a normal litigant has the right to, with agreement of the plaintiff's counsel, file or be involved in a stipulation giving them additional time to answer. There's no specific right for a UM carrier to do that. All of the law says once you're involved, you have to answer within 30 days of service. So technically here, if our stipulation was an appearance that would have required us to answer, our answer would have been required on the date it was originally due. It couldn't have stipulated an extension because that's not permitted under the law for UM carriers. So it would have been moot as filed. But that's more important because the law repeatedly talks about how UM carriers have very general leeway in these cases. They have more rights than an average litigant. They are able to make these choices about whether to answer or not answer. They have the right later to withdraw their answer so that they're not on a verdict form. They can change between being serving in their own name and serving for the plaintiff later on in the litigation. Their rights have, as quoted in the Kelly case, they're given wide latitude. And so here, if it was held that by filing a stipulation extending the time to answer for a UM carrier, that requires the UM carrier to answer and waive defenses, even though it included a non-waiver clause in that stipulation, that UM carrier suddenly has fewer rights than an average litigant. It no longer has that flexibility because suddenly a UM carrier is never permitted to stipulate to an extension of time to answer. When the 30 days have run, it has to answer, or it has forever waived that right without being in default. And that's not the way that this works for an average litigant. If, for instance, I am representing a UM carrier and I receive the complaint on the 30th day, suddenly I have to make sure that we have a decision about whether to answer and can answer and know which party we want to answer in at the time on that same day, or I have no other option to ever choose to answer because I don't have the right to go to the plaintiff's counsel and say, hey, can we get a stipulated extension of our time to answer so that we can figure out what's going on here? So we would be taking rights away from a UM carrier that are in the possession of every other Georgia litigant. And that seems completely contrary to the purpose of this law. I'd also just like to point out some issues with some of the cases that the plaintiff's counsel cited. Several of the cases are not Georgia law, and I think I referenced that in my brief. So to the extent it's not a Georgia case, I'm not going to go through those. And then there's a homeowner's case that's a Georgia case, but it applies New Jersey law. So again, if it's not Georgia law, from my perspective, I don't think it particularly matters here. Plaintiff references the Smith v. Sanders case. That's 360 Georgia Act 286, 2021, and indicates that in that case, the courts found a general appearance had been entered when the defendant filed a jury demand. And he goes on for about a page talking about how jury demands are not pleadings and how such a small filing could involve a party. What's not mentioned there is that the defendant in that case did not just file a jury demand. They also filed a notice of pleading to open default on the same day as the jury demand, and they served discovery on the plaintiff on that same day. So they certainly involved themselves in the litigation and filed actual documents of substance in the litigation to try to open default, and then also involved themselves in discovery at that time. So I feel like that case is very different than the situation here. The Moss v. Bishop case that plaintiff represents repeatedly, both in his original brief and in his reply brief, he indicates in the primary brief that it was overruled on other grounds, but on my reading, it was overruled on exactly these grounds.
That's the Shaheen case.
Oh, I'm sorry, I didn't give you the site for that. That's 235 Georgia 616, 1975. So in that case was disapproved, dicta was disapproved in that case since 1980. And it's on pretty much exactly this issue. The question there was whether appearance at a TRO hearing without raising jurisdiction plea waived jurisdictional defenses. And in the court in Moss held that was the case by showing up at the TRO hearing and not specifically raising jurisdictional defenses. The party, the court had jurisdiction over the parties. In 1980, that dicta was specifically disproved, and the court held that that such action would not automatically confer jurisdiction over the parties. And the case that disapproved it was Shaheen, Shaheen v. Dunaway, Dunaway drugstores, 246 Georgia 790 at 792. And that was from 1980. So I know that was one of the cases that plaintiff focused on a lot about why we would have jurisdiction here, but the jurisdictional part of that case actually was specifically disapproved and would favor, the Shaheen case would favor a conclusion in our favor on this case. But yes, Your Honor, I think just to conclude, for my purpose, I think the most important thing here is that, again, we reserved all rights in the stipulation. We had rights coming into the stipulation to make a decision. We reserved those rights, and because they were explicitly reserved, we did not forfeit them. We still had the right to make that decision. The plaintiff indicated in his argument just now that filing the stipulation is an act in furtherance of litigation, and that we didn't have to get a stip if we didn't want to answer. But that assumes that Crum and Forster knew whether it wanted to answer at the time that it filed the stipulation. I mentioned in my brief, there's really no way for plaintiff's counsel to know what was going on in my mind or in Crum and Forster's mind at the time that this stipulation was filed. There may have been things going on behind the scenes that caused Crum and Forster not to know how it wanted to respond at that time, and for that reason, the stipulation was sought. And for that reason, the stipulation sought to reserve not just the right to answer, if we so choose, but all of our rights and options in the case. We did agree not to file any dispositive motions prior to filing an answer, but that was us giving away a right. It certainly wasn't us protecting one. And that I would reiterate that the agreement to not file dispositive motions does not preclude us from raising jurisdictional defenses in our answer had we chosen to file. So those could still have been raised. I think that's really kind of the bulk of our argument. If you have any questions, I'd be happy to address them.
Just a couple. So, in thinking this through, just to make certain that I'm not accidentally chasing any red herrings after y'all, because it's no secret I'm going to take this under advisement. I'm not going to send me orders. But the fact that it was signed with express permission, I don't need to worry about that. The language that the stipulation says, y'all are good with that language. Like, it's not like, I'm just trying to make certain. I had anticipated all kinds of wonky arguments, and I was making certain that I don't need to worry about the fact that it was signed with express permission, that it wasn't like something was in there that you didn't agree to or something. I can use the language of the stipulation as it is in making my decision.
Yes, we don't challenge the language of the stipulation at all. And I mean, I will admit that I was the one who electrically filed that on the plaintiff's behalf. My signature is not actually on the pleading; it's simply on the certificate of service, as is proper when you're,
That's
making
fine.
a filing on someone else's behalf. But
That's just me being very, very careful and going, okay, so that means I can use the language as it is. I don't have to worry about anything else. And then as far as if it seems to me like the argument, going back to the stipulation, and I've got it pulled up here, where it says, without waiving any of their rights or defenses, may answer plaintiff's complaint. And then there's some other language, and then up to and including Wednesday, August 23rd. Well, obviously, August 23rd came and went, no answer. So, am I correct in reading that, from your perspective, the plaintiff is basically trying to say that this should have said shall answer? Is that an oversimplification of this? That by doing this, that means that you are now required to answer?
I certainly think that would make a very significant difference in the arguments here. I think if we had agreed to the term shall answer, I still think that we would have reserved all of our rights and defenses, but yes, I think by using the term shall answer, we at a minimum would have given notice that we intended to file an answer on that date. And from my perspective, the reading of the stipulation as is suggests that we had an option to decide to file an answer on the date given in the stipulation.
Okay. Okay. Well, I'm certainly feeling better about not being able to wrap my brain around this case, because obviously we're looking, anytime you're pulling these much, much older cases, it's because we don't have anything. In my own research getting ready for today, I couldn't find anything that helped me, that was even remotely recent, that even remotely landed on target. So, I'm getting a little clearer on what I'm trying to figure out here. So, all right, anything else?
I think the one case that I find the most confusing, and I'd like to point this out just generally to the court, is the Home Indemnity Company v. Thomas case, which was 122 Georgia App 641, 1970. That case doesn't have really a statement of facts in it. So they reach kind of a conclusion, but we really don't know what happened before the decision was rendered. It appears to me that it was a carrier that was trying, this, by the way, I'll mention, was only within about 2.5 or 3 years after the statute was amended to give carriers the option to answer. So I'm sure the courts were still trying to figure out how to handle that. This is a very new issue at that point in time. And it appears to me that it was a carrier that was trying to intervene. So they had either defaulted or not answered, not got involved. And then they come into the case, they file a notice to intervene and are trying to challenge coverage elsewhere. And the court is saying, well, you had the right to enter this case here and you didn't, and now you're filing an intervention, but that's you trying to get involved in this case now that you've decided not to be involved. You can't do that. You can't choose not to answer here and then or you can't be in default here and then come in and get out of default by intervening. Now, it's my understanding generally that a carrier who chooses not to answer in a case like this can challenge can challenge coverage in a federal court case, because they would separately have jurisdiction there as long as they don't answer here, or at least that's generally my understanding. But it reads in this case like the party was already in default, so we don't know what happened. But the way that the case reads, I think it's very, very confusing, because I think we don't know what the facts were before the ruling, and I want to bring that to the attention of the court, because I've read it about 10 times trying to figure it out. And my interpretation of it is that I think the carrier somehow was already in default or wanted to answer in the name of the named defendant potentially who was already in default. That part's unclear. And then they tried to basically get themselves out of default by coming in later and filing an intervention. And the court said, yeah, you can't do that. You can't intervene to save yourself later after you're already in default to fix a prior error.
Well, we've certainly seen that a time or two here, where the actual named defendant is in default, but the UM's not, and then they try to come in before trial and undo the default so that they can defend in their own name.
And
And
yes.
I've consistently said, no, like, you're stuck with the procedural posture that's here.
Well, and I think this is your case for that, if you ever need one. But I don't think this particularly applies to the facts at hand, even though I think it reads like we're not sure what happened, so maybe it could apply to anything
Right.
So I wanted to bring that to the court's opinion and maybe see if you reading it in that way makes it make more sense to you.
Well, and again, anytime you start digging into these older cases, we all know you have to tread very carefully. I mean, this case was made before Parnell actually made partner, and he was a lowly associate at Neely, Freeman, and Hawkins. There's no Hawkins and Parnell on there, so.
I thought about giving him, my father's a longtime partner at Hawkins Parnell, and I thought, oh, I could call Al, and maybe he could tell me what happened here, but I did not do that.
But yeah, anytime these things are older, you always have to step very carefully. But I mean, the short answer is I understand why we're here, and I understand exactly why the plaintiff is asking. I understand exactly, now I'm getting it, why y'all are so vigorously wanting them in and so vigorously wanting out. And yeah, this is a big decision. I would go ahead and acknowledge that. So, okay, back. Anything else?
You're not.
I'll give you another chance to respond if you need to.
I don't think so.
Okay, back to you.
Just a couple of things to touch on there. First, I want to make clear that when I'm citing to case law outside of Georgia, it's not intending to say that you're bound by this or anything. It was merely to illustrate what other jurisdictions are doing with stipulations, because there was more case law about stipulations in particular outside of Georgia. And I'm not sure what the majority or minority view is on stipulations. I didn't do a 50-state survey, but the ones that and also you have to forgive me, by the way, when I was preparing last night, I forgot to put my brief in my briefcase, rushing to beat Atlanta traffic, so I don't have specific citations for you other than knowing what's in my brief. But most of the cases we cite that talk about stipulations outside of Georgia, where you see them saying stipulations aren't enough, and home indemnity is actually a good one to look at, either the decisional law in that state overruled a prior practice, or there was a specific statute that was amended to say, hey, we have a public policy of wanting people to be able to reach out to each other and get an extension without necessarily appearing in court. But they needed a statute to do that, right? And so that I think was, we put that there as persuasive authority, not to say that you were bound by it. I still do think the default is a red herring. We're not arguing waiver in this case as a basis for you having jurisdiction. We're arguing that an appearance has been made. And when 33-711 allows a carrier to appear in its own name for one purpose only, and that is to contest coverage. In practice, in car accident cases, carriers always answer in their own name, so they can decide to switch later. They want to do discovery and get those rights. But the reason why we went from a body of law that allowed carriers to intervene to one where they could answer in their own name is so that they could have that right to challenge coverage without having to file an intervention later and risk missing it or filing a separate deck action. We wanted to consolidate these things to make them more judicially efficient. And so we're not arguing that you have to hold them in default and that there's a waiver of jurisdictional defenses that could have been raised for there to be jurisdiction in this case. When we entered into that stipulation, our understanding was we were talking about 911-8, 911-12 types of jurisdiction. You can make an appearance in a case and challenge specific aspects of jurisdiction in the case, like service or personal jurisdiction on the part of the defendant. And we agree that is not waived here if they're not held in default. Even if you granted a default here and found that there was a general appearance, it would be very easy for them to show the 4 or 5 things they need to do to open it up again and still have the right. They would still have the right to change their election when they're preserving those rights. That was our understanding of what they're preserving there. But they can't have it both ways. One of the arguments I heard from the other side was, well, we wouldn't even be able to extend time. We're not allowed to do that. Well, then why did you need a stipulation? Because 33-711 tells you what you can do and when you can do it. You need the stipulation to tell you, judge, when that 30-day marker passes, hey, we've already come to an agreement. Don't do anything sua sponte. Because some judges do that. They'll just hold people in default right away without a motion. You don't even really need a motion to have a default. You're automatically in default by operation of law. The only thing that makes it different for carriers is they don't have to choose to participate if they don't want to under 33-711. So that's why, and I forget the case, I'm sorry, but you mentioned Shaheen. If I said overruled on other grounds, it's because we're not making the argument that there's a waiver here or that the waiver of personal jurisdiction defense is what gets the toe on the ground. It's the fact that they took action allowable by law in furtherance of the litigation. They derived a benefit. They gave up some things too. We didn't want them delaying the case with 9/11/12 motions and delaying discovery if we were going to give them that time to answer. But the toe is on the ground. And we cite to all these cases with different examples of other actions other than filing pleadings. You know, that jury demand case that we referenced, when the court was figuring out when the default accrued, they were looking at when that jury demand was filed. There might have been other things too that made that an easier case than this one. You know, participating in discovery is a big one. You can't say, hey, I'm not subject to jurisdiction of the court, but I'm going to issue something to you you have to respond to. So that made that case an easy call. But all you need is a toe. And when they're talking about, well, now we have fewer rights than we would have had, that's the exact argument that was made in Kelly. Right? Kelly, they were in default. They ended up, I think, filing a motion for summary judgment later, much, much later after not filing an answer. And it was the filing of the motion that put them in default. Had they not filed anything, they would never be held in default. And again, it's because once they participate, they get the same rights as everyone else. And so if you're going to come to the court and say, I need this stipulation because I'm worried I'm going to be held in default if I don't answer, the only reason to do that is because you intended to do it. Otherwise, you just put your hands up and don't do anything. So if you're going to answer in your own name, because that's what they did, they represented themselves on the certificate as attorneys for Crum and Forster, not for the defendant, because they could have done that too if they wanted to participate. The only reason to do it the way they did is because there's an aspect of coverage you want to contest in the case. And that's what gives you jurisdiction to decide the coverage question. We're not asking you to hold them in default and say, now we win coverage. Even if you held them in default, that only gets us the well-pleaded allegations in the complaint, and I didn't plead anything about 33-124, and any affirmative defenses that they'd have to raise in the course of the litigation. Your interpretation of Georgia law and what it commands the insurers and the rideshare companies to do is not an affirmative defense. That question is ripe. They're going to have a right to brief that no matter what. The real question is, can you decide this, or does this have to be Superior Court after the trial? And so all of the case law here, there's no case that's going to tell you these things are good and these things are bad. It's just look at the totality of what they did. What were they trying to do here? What was their intention? And did it further the litigation? And I think why you don't see a lot of cases coming down on the other side of, no, this doesn't count, is because there's very little you can do in court that makes it so you're not submitting yourself to the jurisdiction of a judge, and where you could be ordered to do something. I mean, really, you just have to not participate in litigation at all. And so that the fringe cases you do see are where people are appearing at hearings or where they have already raised the defenses to jurisdiction by special appearance or something like that to preserve them, but then do other things after, like participate in discovery. Case law is unambiguously clear that you can preserve those objections when you file your answer and then do other jurisdictional things, but those defenses are still preserved. But there's no defense that's being preserved here other than saying, we're not here. There's no affirmative defense for, they mentioned service and things like that. I'm not sure if there's a service issue in this case as with respect to Crum, but if they're not going to answer, if their position to you is we don't want to file an answer here, then there is no service defense in this case. So when we talked about preservation and may versus shall, we're talking about whether they're going to file any of those defenses in the case at all, any personal jurisdiction outside of a general appearance jurisdiction. So there are multiple ways to contest different kinds of jurisdiction against different kinds of parties for different reasons, and still say the court generally has jurisdiction over the parties.
All right, I'm going to take something you said and I'm going to pivot back with a question, which is help me understand a little bit better the thought process behind if you have no obligation to respond, then go through it again with me. If you have no obligation to respond, why file the stipulation if you're not going to answer?
We haven't necessarily gone through, what was going on in the background, and from my perspective, largely that's attorney-client privileged. But generally in this case, there obviously is a coverage question, and our client was. I guess what I can clarify generally is that Crum and Forster doesn't just have the liability policy for DoorDash. They also have a accident and health policy for the drivers, where And so they have that's in two separate, completely different parts of this insurance company. And typically, because UM cases, as you know, when they're filed on a UM carrier, they don't have the name of the UM carrier on the case. So when these cases have been coming into Crum and Forster, they get directed not to the liability, they get directed to the entirely wrong department, who then is like, hey, we're not named in this, so we don't have to do anything. And then these have just started coming in. This is a new policy within about a year for Crum and Forster. And so there's been a lot of internal confusion about where these are getting sent. They're getting misrouted because they have two different policies. When they come in without a name on them, they don't know where to send them. And so that's causing them to take quite a long time to reach counsel. But more than that, in this case particularly, there was a decision that coverage needed to be involved. But that decision happened later than it, otherwise optimally would have. I, not representing them in coverage, can't make that determination. So the reason here for the extension was that we needed an extension so that they could determine whether to answer, so they could determine whether they wanted to pursue coverage defenses in this case or not. Which is an entirely, in my opinion, reasonable basis for them deciding to extend their time to answer. Plaintiff says, well, just don't answer if you're not going to answer. But if we don't answer, as Kelly says, we can never come back in and do it, because then we're suddenly in default. We have no other option. We would be entirely precluded from involving ourselves at that point. The only way to give ourselves more time to decide whether to try to discuss coverage in this case or not, is to seek a stipulation, giving ourselves more time to decide whether to answer in this case or not. And that is what happened here. That's why all of these rights were preserved. And it's why ultimately there was a decision not to answer. That decision could have gone the other way. It didn't. But from my perspective, we had both of those rights at the time the stipulation was filed, and that was the intent, to preserve all of those rights. The plaintiff indicated, I think, twisted my words a little bit about whether a stipulation is permitted here. What I'm trying to say is illogical. I think if we take the law the way the plaintiff is arguing it, then a stipulation would automatically be moot in a case like this. I don't think that's true. I think a UM carrier is permitted to file or be involved in a stipulation to extend their time to choose how to proceed. I think had we wanted to have the right to file motions in this, and the plaintiff's counsel had allowed that to be in the stipulation, that could have been there too. I think if we wanted to make a stipulation that specifically said, yes, we will answer, but we need more time to prepare that, we could have done that as well. I think just like any other litigant, we have the right to speak with plaintiff's counsel, have plaintiff's counsel file, upon agreement, a stipulation that gives us time to evaluate what's going on and figure out how to proceed. But if we take the law as the plaintiff is interpreting it and say, by filing that stipulation, suddenly you've appeared and now you have to answer, at that point, we wouldn't have the additional 30 days, because the law doesn't provide UM carrier with additional time to answer, even upon a stipulation, after they have appeared. At that point, they are required to answer within 30 days of service. So that's where it gets nonsensical. And that's why I'm saying I don't agree with his interpretation, because I truly think it makes the law like murky and confusing, and it doesn't make sense for the parties' rights generally. And it takes rights away from a UM carrier that are provided to all other litigants. On the jurisdictional points and general appearance points that he was making, I think it definitely matters whether this is general appearance. I think the law is, again, very clear that this cannot be a general appearance, because we reserved our jurisdictional defenses by reserving all rights. We raise those jurisdictional defenses in our first pleading, in our answer. That's the time to do that. It's common practice for lawyers all over the state of Georgia to get a stipulation on a time to answer and then file a special appearance answer later saying you have the wrong party, or you've named the wrong defendant, or you didn't serve us. Whatever it is, there's numerous reasons why stipulations are filed to extend time, and then later a special appearance answer is filed. That party is not then deemed not to have specially appeared but fully appeared because they had a stipulation previously. So this is very similar to that. the reason why parties regularly extend time to answer is because typically they receive the pleading late and they haven't figured out whether jurisdictional defenses are yet. And that's one of the key reasons why attorneys seek stipulations to extend. If we didn't do that and we answered things too quickly when they're received right at the last minute, often we would be doing our clients a disservice by forfeiting jurisdictional defenses that they should have the right to. So we would be taking the regular use of stipulations to extend in Georgia and providing an entirely different interpretation of the way that that's used specifically for UM carriers. If we held that this required Creme and Forster to have answered. I also think that the plaintiff's misinterpreting the Kelly case when he's talking about the court giving the UM carrier less rights. The court in that case very specifically said, once you involve yourself in this case and you file a pleading, you have the same rights as everyone else, not less. The party in that case, the UM carrier, misinterpreted the law and believed that they could never, ever be in default under any circumstance and that they could file an answer or a motion to dismiss at any time after they had been served. And they did not ever account for that 30-day window. The court said to that party, you still have, the same time to respond as anyone else. If you don't do it, that's fine. But if you do, then you're held to the same deadline, which means the fact that you chose not to answer here until I think it was like 121 days later means that you're in default just like any other party would be. So that didn't take rights away from them. It just clarified the law where they had misinterpreted it or not understood what it was. I don't think that's really the case here. I legitimately believe that by deciding that a stipulation to extend time to answer for UM carrier suddenly requires UM carrier to answer, and again, would technically require them to answer on the 30th day after service, removes rights from them. It effectively eliminates their ability to ever stipulate to an extension of time to answer unless they've already made the decision to answer, which really would undermine the basis for filing a stipulation of an extension of time to answer, especially for a UM carrier. So I believe that the intent of Georgia law is for UM carriers, especially at the start of these cases, before they've made a decision, to have more rights than a general litigant. And then once they have officially and intentionally involved themselves, and a lot of these cases several of these cases at least, use the term substantive action, have taken a substantive action in the case. At that point, then they are involved and suddenly they have all of the same rights as any other litigant, except they do still have a few extra benefits because they can withdraw and things like that. So here, we truly would be eliminating rights for a UM carrier that are available to all other litigants. And I certainly think that's against the intent of the statute in Georgia law. Okay.
And again, I feel a lot better now that I've had y'all here and kind of had our back and forth because, I'm with you. Like, I understand from both of y'all's perspective now exactly why we're here. And frankly, I can see the importance of this decision. And I can see how this would have a pretty significant ripple effect through the other cases. So I'm definitely going to want orders from y'all. And I'm definitely going to take a little bit of time and think about this one and make sure I don't jump off the wrong cliff. So, okay. Anything else on this matter from the defense?
Well, if you're going to be asking for proposed orders from both of us, can I make a very respectful request? I have not filed any LOAs in this case because I've been intentionally not filing. I have LOAs today on all of my other cases because I'm flying to France tonight for the next 10 days. So if I could possibly not have a deadline during that window and have a little time after I get back, I would very much appreciate it.
So we always do 30 days. So the short answer is that let's do a little longer than that. So that'll give you. So let's do about 40 days out. That'll give you your 10 days. So today's the 19th. So I don't know. Let's just do June 3rd. So that's easy. So that'd be Monday, June 3rd.
Thank you, Your Honor.
So yeah, I said I have a life outside of here too, and it drives my defendants crazy, so. Okay, so do we have anything else we need to discuss on this issue? Okay, now moving, so we have the two other things we need to, the one we need to discuss and then the one we need to figure out. So as far as the motion for summary judgment goes, those are hand in hand, but y'all were wanting, I guess, help me understand the procedural posture from the defendant's perspective, now that we're on record and all that. So you were wanting to have time to, I guess, get the decision on this one and then respond to that one? Help me understand.
Honestly, my recollection is that we didn't even ask for that. I think that was offered by your office. I don't know if I have that wrong.
I just don't think it would make sense to spend time briefing anything until a decision came out on this anyway.
On the default.
Yes.
Right, because why talk about summary judgment if it goes one way?
That's a good point.
Effectively, yes. If we're not in default, then we haven't answered. We never had a duty to answer. We're no longer.
And you don't have the ability to rule on it if
Right.
Okay, give me just a second. Are y'all gonna want oral argument on the motion for summary judgment if we get there?
I think because of the magnitude of you're interpreting a statute where there's no appellate law on it, I think that would be a good idea.
Okay, let's cross the default line and then we'll come back across that next one. Again, we normally move these things a lot faster. We normally start bundling them together, but it's the one thing y'all are definitely in agreement with, which is that this is a very important decision that has some pretty far-reaching impacts. I'm feeling it myself. I'm okay slowing this case down just a little bit. We're normally like, let's go, go, go. But on this one, I'm okay with saying, let's just cross this first bridge and then let's come back and go across the second. So, all right, let's move that pace then. All right, so I expect to once y'all get the proposed orders to me though, you should expect a decision pretty quick after that. So, and make sure you send them to, all of us, Word format, of course. So we can, and obviously you're welcome to weigh in if you want. So I think you're up next with the next issue though. So, because I think we needed to talk about trying to find the defendant and your client and get him deposed. Is that on the list somewhere?
Yes, Your Honor.
Tell me what you need.
So there's two ways. Here's what I was planning on doing. I was going to give you a motion with two paths you can take. One where you just compel the deposition and one where you strike the answer because there's clear evidence of willfulness in terms of the non-participation of the defendant. But if you're going to, the reason why I was going to do both is for time's sake because I'm very eager one way or the other to get this on a trial calendar. That's what's going to need to be done, especially if you rule against me. The only way I have the ability to get a deck action is to have a judgment.
Sure.
So we're going to give two alternatives. Compel, if you think there's enough time, you want to give them one more stab at finding him, we're fine with that. But in the alternative, we think there's enough of a factual basis from September till now of just non-participation on the part of the defendant. Strike the fault defenses in his answer. So simple negligence, comparative fault, and non-party fault. And then there's one piece of evidence that I can't authenticate without him. It is I might be able to authenticate without him, but it makes it much harder without him. There's a video capturing the whole thing.
Sure.
So we would want that admitted as part of the sanction.
You've already set the date, right? You've already noticed.
Last week.
So it was last week.
Yeah.
And obviously no show.
Judge, to that point, the day before the depot, I'll backtrack a little bit. Prior to us receiving the case was handled by an in-house counsel, I believe. And at that time, it is our understanding that it was issues getting in contact with the defendant for that depot prior to our office getting the case. And so the deposition was unilaterally scheduled. Once that time came up, our office, after multiple attempts trying to reaching out to our client, reaching out to the defendant, trying to get him to appear for the depot, no contact, left voicemails, everything. So the day before the depo, I reached out to Plaintiff's counsel, like, hey, like, I cannot make contact with this guy whatsoever. And so, in all fairness, we showed all good faith intent to get Mr. Williams there for the deposition. And so, I will object to Plaintiff's counsel striking the answer because I believe there's no willfulness on our part, or we don't know where the defendant is. We don't. Maybe if we send out a private investigator, we don't know, Judge. So I believe striking the answer is pretty intense at this point, considering the fact that this case has gone through 2 offices and the defendant is nowhere to be found at this point.
Oh, I just want to make clear, we're not suggesting willfulness on the part of the attorneys.
Oh, I heard that.
Yeah,
So, and you have to say that, and we're all on the same
Yeah.
page, that obviously you've got to take the hits that your clients are not here
Yeah.
to
But
take.
we want to make sure the court's aware that it was unilaterally noticed because with prior counsel, we couldn't get dates from September through January. So we filed a notice unilaterally in January, giving them until April 9th to find him.
Right.
So this is not like, oh, this is our first stab at it. Yeah, we didn't try to take multiple depositions because we didn't want to unilaterally notice it, but we've had 7 months now of him not participating.
All right, so go ahead and schedule another one, get an order to me, just, I mean,
Compelling.
obviously y'all can talk together, but I mean, just don't, get it scheduled ASAP, as close as you can get, where you're giving them enough time to try to continue finding. They've already had 7 months, so we don't need 7 more months. I just need like 30 days or something. So if you need to unilaterally pick a date, but obviously you now have opposing counsel, you could pick a date that works for both. Chances of you taking a deposition on that day are probably in the 1-digit numbers, but I want to put an order on it, ordering that deposition on that day at that time, and then if he doesn't show at that point, then I will consider, the secondary steps.
Should we just get together and give you a proposed order instead of doing a motion that we agree on the date and then you just compel it?
Y'all are good with that?
That's fine.
Okay.
Okay, that'd be great. So, and just put that, we'll just do that it was hey, when you do the order, just send that it was a verbal motion in open court on the record. And that way there's at least some reference, because I'm technically not allowed to issue orders without motions. So it's in the rules. So, so put in there that a verbal motion was made in open court, it was verbally granted, and the court directed that this order be sent. So, and again, let's just get that done, because that way, if he's not going to show, we need to know that, and I need to be considering my secondary options, which very well may include striking the answer. I don't know. So, but he needs to know that. So, okay. Let me talk to Mr. Hope. Y'all have anything else? Okay, we're good. Mr. Hope is here to keep me out of the ditch. He has an unenviable and 24/7 surveillance job, so. Okay, then, thank you all for coming down. I appreciate it. Again, I just want to say it is always a pleasure to have very good lawyers in this courtroom doing a very good job for their clients. I spend a lot of time trying to keep lawyers and defendants out of the ditch. Y'all have a very important question, and I respect the fact that we're here. And I understand fully now the Georgia-wide implications of this decision. And that whichever way I rule, very likely you all will be posting my order on the listserv saying, hey, everybody, guess what? I just got out of Spalding. So, and I might even post my order on the judge's listserv and say, hey, everybody, right or wrong, I just made this very important decision. So, so I just want you to know I respect the fact that we're here. I understand both of your perspectives, and have a safe trip.
Thank you.
So, what else do y'all need? Anything else?
Well, I don't know if this is relevant at this point for when it comes to defendant Williams. Just covering all my bases, our office did not receive this file until March, Judge. So I know the deposition was unilaterally scheduled, but moving forward, we'll continue to pursue all efforts to get Ms. Williams there. So.
Well, and that's one of the reasons that I'm going with Plan A is because I understand y'all are new, and I want to give you a chance to have yours. But I mean, the fact is that previous counsel wasn't able to locate him and pass him along either. And so instead of just jumping to the answer, that's why I'm doing the step one, schedule another one, schedule it quick and give you all a chance to try to find them, so.
Perfect.
But
Thank you.
yeah, but that's, I respect the fact that y'all are just in, and that's why I'm doing it that way.
Thank you.
But these are good questions. Anything else? All right, great job, everybody. Get us those proposed orders, June, was it June